Sorry, just pause. Let me just go. Continue. Take this call. This guy near here. See, and I'm saying near photocopy 4 and bring. What's going now? Good day, gentlemen. Good to have you back here. The topic we have today ordinarily is the topic assigned to Group 7, and that's the topic that says discuss pre-trial applications. Discuss pre-trial applications. So in order for us to know what pre-trial applications are, or the kind of applications that can be made at pre-trial levels, the first thing we need to know is what actually is the meaning of that word pre-trial. What's the meaning of pre-trial? Pre-trial simply means what is done before the trial. The things that are usually done before trial. So I'm going to give us a little bit of historical background into why the rules of court has incorporated pre-trial precedents. Now, before now, under the uniform rules that the old rules now repealed, what we had was a situation whereby when pleadings are exchanged, that is when a plaintiff files his pleadings and the defendant also files his own pleadings, the matter will be adjourned for mention. Now, after mention, the matter will be adjourned for a date for hearing. And within that period, we discovered that a case could last for donkey years. It was possible for a case to last for more than 10, 15 good years. Yes. Why? Because of the procedure that was being applied within that very period of time. For instance, during mention, when the case is coming up for mention, you discover that more or less the court is not doing anything that day. It's just to ensure that A has filed his papers, B has filed his papers. That means plaintiff has filed, defendant has also filed, and then you start talking about agreeing on a date for hearing to begin. Now, even the process of filing was also time consuming. Time consuming in the sense that under that very old rule, the first thing a plaintiff did was to file writ of summons. After filing writ of summons, he could even wait for maybe donkey, even until the writ expires. He can bring an application for the life of the writ to be extended. After wasting like a whole 12 months doing nothing, the next thing he comes up with an application for extension of time to file his statement of claim. And after filing the statement of claim, he waited for the other party to file his statement of defense. And then, too, after mention, the matter is adjourned to a date for hearing. And the pattern of hearing was that the plaintiff would call a witness, maybe call one witness one day who will come and tell stories upon stories upon stories. The judge may be so bored, but there was nothing the judge could do. All the judge could do was simply to record whatever the witness was saying, and then we discover a situation where a witness may give evidence on 4 or 5 consecutive times, or even more than that. What I mean by that is, a witness testifies today, he tells you he's tired or he can't continue for one reason or the other. The case will be adjourned to another date. He comes and joins from where he stopped, continue giving evidence at a particular point in time. He may not even finish that day, and there's nothing you can do. You adjourn until the witness was able to conclude his evidence. And then after that, the defendant will check the ground, the defense counsel, to start to cross-examine that very witness. A defendant will now see it like, if this witness was given 3 adjournments to give evidence, why would I be given one day to cross-examine? So you also see that pattern of delay also coming up from the side of the defense. Now, that was why you would see some cases that will last up to 10 years, some even 20 years. I'm not exaggerating, it happened. So because of this, there became the need to ensure, one, that court matters, court lists are decongested, and that matters are expeditiously heard and tried, so that let the matter end one way or the other. If A is aggrieved, let him go on appeal. If B is aggrieved, let him go on appeal. So there was no need for all this time wasting pattern. Now that paved way to the modern civil procedure practice that we have adopted today, which is that when you file your action, you accompany it with the requisite documents, such as all the documents you're going to rely on. You run photocopy of them, front load them to your processes, which is going to include, of course, your read of summons, your statement of claim, list of witnesses, list of documents, and the documents themselves. You form the bundle and you throw in the bundle at the same time you're filing it. You file the entire bundle. Now you discover that this is a fast way to avoid all those unnecessary delays. With one process, you have been able to achieve filing of your writ of summons. You have also achieved filing of your statement of claim without making unnecessary application for extension of time. You have also front-loaded all your written statement of written statement on oath. Everything your witness are coming to court to say, they have put them down in writing, and you're putting them in bundle, and you're filing everything at the same time. Now, when this bundle is served on a defendant, the defendant is expected to react, respond, except maybe where he believes that he has no defense, and maybe he considers. But we're looking at a scenario where you're going to have a full trial. The defendant has a defense and is willing to defend his matter. So what happens? The defendant files his memorandum of appearance. Like I told you, some rules of court will give you 14 days to file a memorandum of appearance, after which you will now have like 21 days, 30 days, as the case may be, to file your statement of defense. But I always advise that it's better to put everything together. There is no volume of case that if you find make out time, you cannot sit down within 7 days and prepare your statement of defense, except if you're too lazy to do that. Now, so what I'm trying to encourage is prepare your statement, prepare your memorandum of appearance, your statement of defense, the accompanying documents, list of witnesses, list of documents, and the documents you intend to rely upon. Get your own bundle, also file at the same time. Right. Now, when you have filed as a defendant and you have served the claimant or claimants, this is when it is said that pleadings have been exchanged. At this point in time, you have exchanged pleadings. So the next thing will be to set in motion the pretrial stage. Some rules of court call it pre-hearing, a special election petition act, electoral act, call it pre-hearing, which is also, it means the same thing. Now, when all these pleadings are exchanged, it becomes the duty of the claimant to apply. Remember what I'm saying? Apply. He applies to the court for issuance of pretrial notices in the prescribed forms. When he makes this application within the time limit and the time granted him to do so by law, he is availed with the necessary forms and notices where you have the questions, you do your answers, and then as a claimant, you serve it on the defendant. Later, we're going to look at the provisions of the law so as to acquaint ourselves with the consequences of non-compliance. This is a very fundamental thing to do. Now, when a claimant files his pretrial notices, which includes the questions and the answers, and he serves them on the defendant is expected to file his own pretrial answers. Some of the questions you are going to expect to see there will be like whether you've been needing expert evidence, whether you are admitting more than you have done in your pleadings, whether you think that this is a proper case to go to ADR, multi-door court, and so many questions, and then in the end, you are asked to formulate your issues for determination. Now, most of the time, that is also where people get it wrong. You discover that I believe that it is not apt for you to, at this stage, ask somebody to formulate issues for trial or issues for determination. And that's why maybe the claimant will simply say, my issue for determination is whether the claimant has proved his case. That is not an issue. An issue for determination arises from the narrow scope that has been left out after issues are joined. What am I trying to say? When issues have been joined and issues are narrowed, the narrowness of that issue naturally is what points at what should be the issue for determination. And most of the times you discover that issues for determination are better left until the end of the trial, because you don't know how my witnesses are going to react in court. You don't know whether they are going to give evidence that will help my opponent. You don't even know whether the opposing witnesses are also going to give evidence that will in effect assist my case. It is better to allow issues for trial to the end of trial before you can be able to formulate an appropriate issue for determination. But since the law has put it this way, all you have to do most of the times is to conjecture. And that is why most of the times, by the time the real final address comes, you discover that most at 90% of the situations, you see a marked departure from the issues for determination already formulated in the pretrial answers. Okay, be that as it may, pretrial simply means, like I have said, when issues are joined, you have filed your statement of claim, and then your defendant has filed a statement of defense. You look at it, you have any reply, you file your reply within 14 days, apply for issuance of pretrial notices, serve it on me, so that the pretrial proper will be set in motion. Now, if pretrial session is set in motion and any party refuses to attend or abstains from attending the pretrial session, judgment will be given against him. And when you look at the law, we are going to look at it. It also says that if the plaintiff, if the claimant fails to apply for issuance of pretrial information sheets, the defendant may apply. But I want to tell you that no defendant has that kind of a time. If the relief available to the defendant is that, claimant, you have not filed, I can dismiss your case. If I can dismiss your case for non-compliance, why would I be the one to comply? So there is another aspect of the rule that begs for, raises a lot of questions. But we just go ahead to look at some of these rules now, and then we extrapolate most of the provisions and see how they go. So I want to look at my focal point right now is to look at the Abia State High Court Practice and Procedure Rules 2021. Most of the things you will see here, you also see in the rules of court of other states. Now, looking at Order 25, it is headed Pretrial Proceedings and Scheduling. We look at Order 25, Rule 1. Let's go to Order 25, Rule 1. Order 25, Rule 1 says, Sub 1 says, within 14 days after close of pleadings, the claimant shall apply for the issuance of pretrial proceedings notices in Civil Form 17 in the appendix. Now note that this thing is after 14 days. After 14 days of close of pleadings. When is pleading said to have closed? If the plaintiff or the claimant has served the statement of claim on the defendant, and the defendant has also responded by serving his own statement of defense, the claimant still has the right to look at it and file a reply to the statement of defense. Once he files that reply, that is the close of pleadings. But if he doesn't have need to file reply, then once you receive the notice or a statement of defense, pleading has closed. Pleadings have closed. In that case, you now have recourse to Order 25, Rule 1, Sub Rule 1 by making the application. Now, in most cases, what lawyers do is to simply go to the form, prepare the form themselves in accordance with what is provided at the back of the rule, Form 17. They can just prepare Form 17, file in court, and serve on the other party. It is very wrong to do that. It is very, very wrong to do that. The correct thing to do is you have to make an application to the court. And the application here naturally goes to the registrar. But nothing stops you when you are making your application to attach the forms, the prerequisite forms to your application. But you cannot on your own issue pre-trial notices without first of all making this application. And then, because the word used here now is shall, the claimant shall apply for the issuance of pretrial proceedings. So there's just no way you can, play away with that. So look at sub 2. Order 25 for 1 sub 2 says, upon application by a claimant under sub 1 above, now listen, the registrar shall cause to be issued to the parties or their legal practitioners, if any, a pretrial proceedings in civil form 17. You don't understand why I say it is wrong for a lawyer to, on his own, suo motu, copy the form in form 17 and serve on his opposing counsel. No, he can't do that. The proper thing to do here now is to apply to the registrar. It is the duty of the registrar to issue that form 17 accompanied by pretrial information sheet as in form 18. I'm going to tell you the purposes for those things. But let's briefly look at these forms. What are these forms even talking about? I'll briefly tell you the contents of form 17. Form 17 says pretrial proceeding notice, order 25, rule 1, sub rule 1. In the High Court, normally you do your heading, you put the suit number between, you describe the parties, and then it starts with to insert the names of the parties. Take notice that you are required to attend court. It is the registrar that will tell you when to attend court, because you are not the one to give date. Having made the application, the registrar will look at this and give you the date. At the High Court of Abia State, at the Judicial Division of so they will put the date for pretrial conference for the purposes set out here under. So even form 17 itself tells you the purpose for these pretrial proceedings. What are the purposes? The purposes are: 1, disposal of non-contentious matters which must or can be dealt with on interlocutory application. I'll still explain more on this. B, giving such directions as to the future course of the action as appear best adopted to secure its just, expeditious, and economical disposal. That is within the discretion of the judge. C, promoting amicable settlement of the case or adoption of alternative dispute resolution. The court will also look at the facts of the case and then ask you people whether you are willing to go there. In some of the cases, the court may look at the matter, maybe seeing that it's a family matter, the court will simply refer you to the multi-door court for arbitration. And then further down here says, please answer the questions in the attached pretrial information sheet in Form 18. So we are going to look at Form 18 later on a separate sheet and submit 7 clear days before the above mentioned date. So when the registrar serves you with this paper, you have 7 days to answer to the questions and serve. So if you file it before 7 days, no problem with that, that's good. But if you file it after 7 days, definitely you're out of time. So you're going to have to be asking for extension of time to regularize that very process. Ending of it says, take notice that if you do not attend in person, or by legal practitioner at the time and place mentioned, such proceeding will be taken and such order will be made as the judge may deem just and expedient. In other words, if you are served with this pretrial information sheet and you ignore to answer, and then you also ignore to attend court on that very day that you are required to attend, judgment may be given against you. I will also talk more on that. Now let's look at Form 18. What is it all about? Form 18 has the same pattern, heading. We are now acquainted with heading. Then we look at preamble. The preamble says this pretrial information sheet is intended to include reference to all applications which the parties would wish to make at the pretrial conference. Applications not covered by the standard questions raised in this pretrial information sheet should be entered under item 12 below. So if this format does not cover all you have in mind, nothing stops you from doing what? Adding a sheet and adding a sheet of paper to state some of those things you feel that will be needed for your case. Then we look at the other contents of this from Erin. It says all parties shall not later than 7 days before the first pretrial conference file and serve on all the parties. Now listen. 1. All applications in respect of matters to be dealt with before trial, including but not limited to the matters listed hereunder. If after pleadings are exchanged and you have need to make an application for injunction, this is the time to file it. You have need to make an application for the court to permit you to enter into the land for the purposes of surveying the land. This is the time to do that. Or there are other applications, maybe an amendment. You can still bring an application for amendment within this very period. And mind you, it's saying 7 days, 7 clear days before the hearing, before the first pre-trial. B, written answers to the questions contained in this pre-trial information sheet. Those are the things you're expected to submit. Now, we still go down. What are the questions? Some of the questions here are: 1, do you require these actions to be consolidated with any other action or actions? If so, give particulars. If, for instance, there is a sister case that's already pending, there are things people do at times. Because you sue me, I will turn back and sue you, instead of maybe concentrating on my defense to defend the action. Some people may just want to also sue. So when you have two cases, one from the plaintiff, one from the defendant, it becomes convenient and good practice to have them done what? Consolidated. There may be little differences, but then so long as they touch on the same subject matter, so the court can, when you're answering this question, whether you intend to consolidate this case with another one, if the answer is yes, you put yes. If the answer is no, you say no. Then next one, are amendments to any originating process or other processes required? Most of the times, at this very point in time, there may not be need for you to make any amendment, but it's advisable for you to say yes. Why? Because no one case is perfect. No particular plea, nobody can draft a perfect pleading. So that's why when I see something like this, amendments to any originating or other process, because you don't even know what other processes you're going to bring in, the answer is normally yes. Why? Because it opens doors for you to apply at the appropriate time to make amendments. 3, Are further and better particulars of any pleading required? If so, specify what particulars are required. If, for instance, there is something I had been served and paragraph so are not clear to me, or some of the things the plaintiff is saying are not quite clear to me, and I need further and better particulars, I can say yes. Let me be furnished with further and better particulars. So to play safe, the answer here is yes. Even if in the end it doesn't spoil your case, it doesn't taint your case in any manner. And then we go further. Do you object to any interrogatories that may have been delivered pursuant to Order 26, Rule 1 of the High Court? Do you object to any interrogatory? You know what interrogatories are? Maybe you have some information within your custody, excuse me, and then the court needs it or the other party needs it. The idea is to ensure that cases are heard on the merit. Trial is not magic. Trial is not a game whereby you want to cheat out on the other person. No. Trial, as an officer, every lawyer is an officer in the temple of justice. Your duty is to assist the judge to present a better perspective of the matter so that in the end, the judge can arrive at a just decision, or at least seemingly just decision. So that somebody who comes to court will say, yes, I was in court today, I'm satisfied with what I saw. We have hope in the judiciary. So that answer will also be yes. It may arise, it may not arise. Next one is, do you object to produce any document in respect of which a request for discovery has been made pursuant to Order 2608? Naturally, the answer is no. Because if you have a document that is fundamental and crucial to your case, and you are withholding it, one, the law allows the judge to interpret it to mean that you are withholding evidence that ordinarily would be detrimental to your case if you had tendered it. So that's why we have to be careful in stuff like this. That evidence being required here may be evidence that is not even in your custody, but in the custody of your witness. What if your witness is subpoenaed? Once your witness is subpoenaed, he becomes a competent and compellable witness and the witness of the court. And he risks quasi-criminal action against him if he fails to bring it. So to play safe, you just say yes. And then again, if you intend to make additional admissions, give details. Most of the times we simply say no, because admissions naturally will be against your case, except maybe if you feel the fact to be admitted is not injurious to your case. In that case, you can say yes, and then you give details of the particular one that you want to admit. But if there is nothing for you to admit there, you can simply allow that to be. 7, will interpreters be required for any witness? That's when you have to be a master of your case. Not just like you being a master of your case, you also need to know the kind of witnesses you need. You may have witnesses who, although can write and speak English language, but they could be more comfortable in their local language. There's nothing shameful about it. There's nothing wrong about it. Maybe a witness saying, yeah, I'm a graduate, but I think I feel comfortable. For instance, somebody read history and the person wants to testify and say, I want to speak in Igbo. And somebody, you are a graduate. Say, yes, sir. I'm not used to court. I want to make sure I understand the language. I want to be sure that I am not bullied by the lawyer's grammar. So there's nothing wrong in your saying yes. We may be needing an interpreter. You can put it that way so that if occasion arises for you to bring in an interpreter, you need an interpreter, you will request for it, is for the court to give you an interpreter. So there's nothing shameful about it to say, no, no, I'm bringing people who speak English. It doesn't mean anything. Is this a case in which the use of a single or joint expert may be suitable? If not, state reasons. So you look at the case you are handling. And when you're answering this question, you ask yourself, would I be needing expert evidence in respect of this very matter? Would I be needing expert evidence? If you'll be needing expert evidence, you say yes, and you state why. Let's say, for instance, now I'm defending a case where NPDC has been sued, damages are being claimed for oil spillage, and I know as a matter of fact that in the end, I'm going to need some experts to give evidence to show that actually there was no oil spillage, or assuming there was oil spillage, it wasn't such of a magnitude that is being painted by the defendant. Let me also give an instance of maybe where, maybe an election matter, election petition. I have applied maybe for results, certified true copy of results from INEC, and they didn't oblige me, but I have some results. Now, I can say, yes, I will need an expert evidence. Why would I need an expert evidence? Let the experts come and bring the bundle of all the results brought from the custody of INEC to tell us whether those results were written by one or two or three persons. Do you understand now? So that is some of the cases where you'll be needing expert evidence, and so on and so forth. And then again, to maybe finally on this, let's say for instance somebody has sued your company. Maybe your company manufactures Coca-Cola. Somebody said, I saw a debris as I was drinking the Coca-Cola. I suddenly noticed debris at the bottom of the bottle, and then the person takes an action. You need an expert evidence to show whether that debris you saw was detrimental to your health. So either of the parties may need expert evidence in that regard. So we still go down. Is there any way in which the court can assist the parties resolve their dispute or particular issues in it without the need for a full trial? This is the major reason for pre-trial proceedings. One, because if your answer here is yes, the judge can simply take you people into chambers, listen to you, see how to sort out this matter, discuss it just like a family, and the matter ends. Maybe this is a matter that should have taken up to 5 years in court, 6 years in court, but because both of you have agreed to subject yourself to the assistance of the court, for the court to look into this matter and say, "Okay, sorry." I have in the past had issues like that. There was this matter we are doing. It has to do with somebody's will. The siblings of my client wanted to dispossess him of, the things that the father gave him in the will. What was their reason? Funny enough, they were saying, when our father was alive, you were always fighting him. And so what? The will has said, I hereby bequeath and give so thing to so person. Your father in that will never said, this my son fought me. You never said, I am disinheriting him. So why would you, as a co-beneficiary, be the one to dictate whether your brother gets something or your brother doesn't get anything? So in such a matter, the judge looked at the man and said, Counsel, can I see people in chambers? And we say, yes, my lord. So we just go there and the court will look at it, talk to both parties, calm, you know, calm the nerves and have the matter settled. Then, have you considered some form of alternative dispute resolution ADR procedure to resolve or narrow the dispute or particular issues? If yes, state the steps that have been taken. Now, this place is simply asking you, before coming to court, were there any attempts or was there any attempt to have this matter resolved? If there was, then what Scotto did? Why didn't it work out? Can the court continue from where people stopped and ensure that in the end peace reign? Come on, pause. Pause. So just give me 2 minutes. I'll be back. I'll be back in the next 3 minutes to continue. I'll be back in the next 3 minutes. continue from where we stopped. So I had to take that very short break. Now I stopped at question number 10. Now question number 11 says, state any question or questions of law arising in your case, if any, which you require to be stated in the form of a special case for the opinion of the judge in accordance with Order 28 of the rules. Now, some of the times, people misunderstand this to mean issues for determination. Issues for determination can well be covered under this. But the main plank of this very question is to find out whether there is a case stated. It requires you to submit a case stated to the court. Case stated simply means if there are some areas of the law that you do not understand, or you don't have any clear authority as to what to do, you can submit that issue to the court. It could be that when the court answers the question, it will help to solve the entire matter or solve substantial part of your matter. And then we look at the last question. It says, list the applications you wish to make at a pretrial conference. Now, it may not be, if you can remember all the questions you can make at your pretrial conference, you can go ahead and do that. For instance, you can say, I'll be making application for extension of time. You say why you need it. I'll be making application for injunction. I'll be making an application for receivership, especially where a property is in dispute, and maybe you feel the other person who is in possession of the property is collecting rent and using the rent to fight you. So nothing stops you from bringing an application for the court to appoint a receiver who will receive the money that ordinarily should have gone into the wrong purse. So the court can order the registrar to receive the money, open an escrow account where the money will be paid in, so that in the end, if A is favored to take the money, he takes it. But if, for instance, the judgment of the court is like split the money, then it could also be split in accordance with whatever decision the judge is going to make. So I have been able to tell us what Form 17 and 18 look like. So we'll go back now to the other nitty-gritties of pretrial proceedings. Having mastered the issues of forms, what I'm expected to do in the form, I will, as a claimant, I have made an application, forms have been issued to me, I have filed my reply, served on the other party who has also filed his own. So the stage is set now for pretrial. We move over to 2. Okay, that's sub 3, Order 25 sub 3. We say that if the claimant does not make the application in accordance with sub rule 1 of this rule, the defendant or defendants may do so or apply for an order to dismiss the action. I earlier pointed out at this. If the claimant fails to make an application for pretrial forms to be issued, you as a defendant, you have two options. Either you can apply and say, my lord, let the pretrial form be issued since plaintiff has not done, or you simply apply that the matter be dismissed. So if it were you, what would you choose? I know that a lot of people will prefer to choose to make application for the matter to be dismissed. Good. But then you know that any judgment gotten at this stage is more or less a default judgment that can still be set aside. So that is why most of the times, taking maturity of parties into consideration, a defendant may decide, look, I have a good case, I have a good defense. I want this matter to be heard on the merit. I don't want the court to dismiss this matter at this, preliminary stage. For this person to now bring an application for releasement and all that to set aside the judgment, so the defendant can still go ahead the pretrial notices. So that, like I said, comes with experience in practice. He's the one calling. So he should sign. Okay. Now I move further to look at the other sub of the rule, order 25 rule 2, which says at the pretrial proceedings, this is what will happen at the pretrial proceedings now. At the pretrial proceeding, the judge shall enter a scheduling order for this, just like under now. Listen to what the judge will do, how the judge is going to schedule the pretrial. 1. Joining other parties. If, for instance, there is need for parties to be joined, other parties to be joined, this is the proper time for the application to be taken. The judge may say, okay, I'll first of all take application for gender of parties before moving over to the next one. The next one is amending of pleadings or other processes. The judge may decide after joining parties, I will allow amendment. After amendment, I will ask for motions to be filed if none is in existence. I will tell you why we talk about filing here. Because at pretrial stage, all motions are supposed to be in, but nothing stops somebody from still filing motion within the pretrial stage, because by law, pretrial proceeding doesn't end in one day. Pretrial proceeding doesn't end in one day. So if it doesn't end in one day and it ends up to 30 days, that means I can still do something within that 30 days before the end of that pretrial proceedings. And then any further pretrial proceedings can be conducted. It all depends on how the judge wants to do it. Any other matter that is appropriate in the circumstances of the case. In other words, the court will now draw out the agenda. During the pretrial, the court will draw the agenda and tell you, gentlemen, this is how I want us to move so that we will have expeditious trial in the end. Rule 3, order 25 rule 3, at the pretrial proceedings, the judge shall consider and take appropriate action with respect to such of the following or aspects of them as may be necessary or desirable as follows. 1. Formulation and settlement of issues. The judge may, as at that time he has already read your processes, so the judge may say, in my view, I think this is what is at stake. This is what I want us to channel our focus on. This is what the issue I want us to address on. So the judge can do that during scheduling. This is called scheduling now. Amendments and further and better, at that particular point in time, the judge can also take amendments, consider whether there are admissions, and then any other thing the court discovers to be necessary to do. That is when the court now uses its own discretion to pattern the matter the way he wants. One of the important things that a judge does at this stage, one is tendering of exhibits. The judge may ask you if the exhibits A wants to tender is being objected to by B. If the answer is no, the judge can allow the documents to be tendered at that very stage. Some of the times, the judge may say, okay, how many documents do you have? You say, I have 30. This one, how many? I have 10. The judge will say, okay, we will wait until during hearing. When you tender, if there is any objection, we take your objection at the hearing stage. In other words, it's scheduling. It's the discretion of the judge. The judge determines what happens at this very stage. And another important thing the judge will also do is to apportion dates. That is the drawing of the timetable. The judge will now say, okay, Mr. Clement, how many witnesses do you have? Clement said, I have 5 witnesses. Okay, I'm giving you 3 days. The judge will give 3 days to the claimant to open his case and close his case. After that, the judge will also give maybe 3 days, 2 days, depending on the number of witnesses that the defendant has. Will also give defendant the number of days that will be suitable for the defendant to open his defense and also close his defense. Then I also want to look at Rule 4 of Order 25. Rule 4 says the pretrial proceedings or series of pretrial proceedings with respect to any case shall be completed within 3 months of its commencement unless extended by the judge or within this timetable. As far as practicable, pretrial proceedings shall be held from day to day or adjourned for purpose of compliance with pretrial proceedings orders. There are things we need to take home from here now. In pretrial, the judge may order that pretrial be taken day to day, but we know that in practice this is usually difficult, except maybe in election matters. Why? Because the judge has a lot of other cases. There are other litigants who also have their matters, they also have to be heard. So the scheduling is just to enable everybody to have a bite. So one other thing, so the judge may decide to say, I will hear your pretrial matters 4 consecutive days. There's nothing wrong in that. Or the judge may say, I will hear it once in a week. Nothing wrong in that. But the point is that the time limit is what? 3 months. And now there's something important you need to know about this time limit. I was consulted to apply to set aside a judgment obtained during pre-trial. Now, when I studied, I made applications, got record of proceedings, studied the case, and I discovered that what actually happened was that on the first day of the pre-trial, my client was absent, and his lawyer was also absent, and the judge did not make any inquiries to find out why are these people absent from court. The lawyer to the claimant made an application referring to this order. My lord, the order said that if any client, any litigant or lawyer does not cooperate, my lord can give judgment at this stage. My lord agreed with them and gave judgment. But prudence would have dictated that, first of all, this is the first time this matter is coming for pre-trial. These people are not here, and the judge may be enjoined to order for hearing notices to be served on the other party to ensure that they are aware. Right. Now, one of the grounds upon which I was able to set aside the pre-trial proceedings was for me to argue that, first of all, after bringing my application for extension of time to set aside the judgment, one of my grounds was that my lord was in error to have held pre-trial within a day and concluded it within a day when the law says that it should not be more than 3 months. So that is a very fundamental issue to also consider. It's a different thing that the both parties appear in court and pre-trial ends in a day. Good. There's nothing wrong in that. But when one party has absented, it is my view that you cannot give judgment against him. If he has filed all his papers, all his pleadings, the pre-trial information sheet simply because he has not attended court for 1 day of the pre-trial proceedings out of the entire 3 months given to him or given to both parties. So this is one of the important aspects of pre-trial proceeding that I think we need to know. And then again too, after pre-trial or series of pre-trial proceedings, the judge shall issue a report. This is very, very important. This report shall guide the subsequent course of the proceedings unless modified by the trial judge. What is the report? The judge has held his pretrial proceedings and he's writing a report. This report will be distributed to parties. In his report, let me just sum it up. He may say that pretrial started on so day. Claimant stated he has 10 witnesses, he has 20 documents. Defendant the same, he stated defendant's own. And that the court in scheduling has given the claimant 5 days to open and close his case, and another 5 days for the defendant to open and close his, and then apportion days for filing of final written address. It can also be done scheduled at that very stage. There's nothing wrong about it. So what this is simply means that the judge is going to do a summary of what happened. And this report is not written as a matter of course. It's not something that is treated with levity. It's a very important material. Why? Because it guides both the court and the parties. If, for instance, claimant has been given 5 days to bring in 20 witnesses, the claimant will now go home and do his schedule of witnesses. On the first day, I'm going to call 3 witnesses. He surrenders his scheduling, witness scheduling to the court. My Lord, on my face, I want to call 3 witnesses. He must abide by the report of the court and by the scheduling, except maybe there is something that has happened beyond his immediate control and the judge is minded to grant an adjournment or extension of time. And then we look at sanctions. Rule 6. Where a case is deemed suitable for ADR under Order 3 Rule 11 or has by directive been referred to ADR under Order 3 sub M of this order above, the ADR judge shall, in case of recalcitrant parties, consider and give appropriate directive to the parties on the filing of statement of case and other necessary issues. What does this tell you? The judge may ask you to go for ADR. Some people may be willing to go for ADR. Some people may be recalcitrant. That's what this place is talking about. Some people may simply say, I don't want ADR. I want the court to decide the matter. Let's go down and see what happens. The claimant shall file his statement of case within 14 days, where the court has ordered, file your statement of case in order that ADR may take place. Defendant shall file his response within 14 days. Where a party fails to comply with the directives and order of the ADR or judge or fails to participate in the ADR proceedings, the judge shall look at the powers of the court. In the case of the claimant, dismiss the claim. In the case of the defendant, enter judgment against him where appropriate. I have an issue with this rule. This looks like compelling somebody to submit to an ADR. There are people who have more confidence in court than ADR. So I believe that it is better to allow a party to have a choice. If the judge says, I'm referring the matter to ADR, and party A feels, I don't want ADR, I want the court to do, because it's a court order, he can appeal against it. Nothing stops him from appealing against it. So I don't believe that it is good to compel a party to go for ADR, especially where the party has reasons to be avoiding the ADR. Maybe you know somebody in the ADR who is okay, you have come here at last, and then you know the rest of the story. Rule 7. If a party or his legal practitioner fails to attend the pretrial, we're back to pretrial proceedings now. If a party or his legal practitioner fails to attend the pretrial proceedings or obey scheduling or pretrial order, or is substantially unprepared to participate in the proceedings or fails to participate in good faith, the judge shall look at the powers of the judge here now, where a party does not participate or is unwilling to participate in pre-trial. I'm not talking of ADR now, in pre-trial, which is being done by the same court where the suit has been filed. The judge can do any of this. In the case of the claimant who is unwilling to participate, the court can dismiss the claim. In the case of defendant who has not come, who is unprepared, the judge can give judgment against him. And then sanctions. Any judgment made under this rule may be set aside upon application made within 7 days of the judgment of such order as the judge may allow. So if a judgment is given against your client because your client did not participate in the pretrial or seemed to be unprepared, or the lawyer was also unprepared, and judgment is given, you have 7 days to do what? To apply to set it aside so that the matter will be heard on the merit. That kind of judgment is called what? Is a default judgment. Now, when you are making the application, it shall be accompanied by an undertaking to participate actively in the pretrial proceedings. This is very, very necessary. When you are making the application, one of the things you are going to avow in your affidavit in support of your motion is that you will hereby undertake that if your application is granted, you will no longer abstain from the pretrial proceedings. You will follow and participate in the pretrial proceedings to the end. And then the last provision is Order 25, Rule 8. The judge shall direct the pretrial proceedings with due regard to its purposes and agenda as provided under this order, and shall require parties or their legal practitioners to cooperate with him effectively in dealing with the pretrial proceeding. This is just talking about lawyers cooperating with the judge to ensure that the pretrial proceedings is successfully conducted. In practice, most pretrial proceedings may end in a day, except where you have series of motions. So as you're taking the motions, you are still taking the motions within what? Within pretrial period. That's why the law looked at 3 months. Right. And for me, I didn't feel that 3 months is too long a time. If the essence of this rule is to ensure expeditious trial and disposal of matter, I think 1 month will be okay. 1 month, some days, will be okay to handle every